Okay, welcome. This is lecture number 8. We're starting unit 2 on the relationship between police and persons on the street in particular. And this lecture is going to talk a bit about the Fourth Amendment, go over some of the background you need to understand Terry v. Ohio. Your assignment for this week, the week of September 14th, is to read closely and respond to the court's argument and the dissenting opinion in Terry v. Ohio. So that's what this lecture is about. In subsequent lectures, I'll discuss the other cases we have. Again, we have a line of cases. They're not exactly the same. The facts are different, but they're all Fourth Amendment cases. And these are 4 out of many hundreds of Supreme Court cases on the Fourth Amendment, and certainly many thousands in the lower courts. So we're just scratching the surface, trying to get a sense of how this dynamic works in this context. So I'm going to share screen and pop up the PowerPoint, and we'll go to slideshow, play from current slide, play from start. I don't have my animations on this PowerPoint, so maybe a little less jazzy. So I want to cover a few background things just to get us all on the same page before we delve into Terry. In American constitutional law, the power of the courts and the role that the courts play in public policy making and in sort of framing political debates has to do, in part at least, with a basic tension in the American political tradition, if you'll grant me that, the American political tradition or the American mind. And from the beginning, there was a sort of natural law, higher law background to our political discussions. The revolution was fought in the name of popular sovereignty. That's why people who wanted to break away from England risked their lives. So our political structures, our constitutionalism, reflects this basic tension between popular sovereignty on one hand and fundamental rights and the rule of law on the other. We value both. They exist in tension. They play out differently over our history. But the idea is we favor and endorse democracy, usually approximated by majority rule, but we distrust it at the same time. And the idea here is an idea for legal studies, and that is that even in democracy, the majority cannot be allowed to rule unproblematically, cannot be allowed to rule without limit, cannot be allowed to rule arbitrarily and capriciously, because the enormous power of the government is entrusted to this idea of the people governing themselves. But there are limits. And the limits side of the tension we play out at the level of ideas, with the idea that the Constitution is somehow fundamental law, has a meaning, constrains what ordinary politics can do. And institutionally, in having courts, and courts often constructed in a way that we can plausibly say that there's in some sense, separate from politics. So, for example, on the federal level, judges serve for life unless they commit crimes and they're impeached. They're there for life. That's to insulate them from popular pressures. And very early on, some argue it was there in the Constitution all along. Some say it was an early invention. We're not going to get into that here, but the practice of judicial review has been with us since the early days of the Republic, and that is the authority of a court to examine a government law or practice for its consistency or inconsistency with the Constitution, and then to uphold it as constitutional or strike it down as unconstitutional. In the cases we're about to talk about, we have police practices that amount to policy, but that's the government acting. And those police officers are acting knowingly or unknowingly on some understanding of what the constitutional limits are. So we do have federal courts reviewing state practice in the form of what a police officer does or is allowed to do. So that's one sort of background point. This is the Fourth Amendment, and we're going to be concerned with the text here. I've highlighted some of the. Actually, I can highlight a lot more, right? Like what's a search, what's a seizure. But for our purposes, I've highlighted the relevant terms that we need to pay attention to. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, testimony, facts, and particularly describing the place to be searched or the person or things to be seized. Obviously, we know we're talking about law enforcement. We know we're talking about values such as privacy, but a lot of these terms are not self-evident. Um, After the word violated, one might expect a period, but one doesn't get a period, one gets a comma. Um, the issue for our purposes is how are we going to understand and know what unreasonable means? Assuming we call it a search, assuming we call it a seizure, whatever it is it reasonable or unreasonable? And one argument that's ultimately rejected is that you want to define unreasonable in light of probable cause. Probable cause of what? Probable cause that a crime has been committed, that it's more likely than not that a crime has been committed, is being committed, or is just about to be committed. And if you don't have that, the argument goes, then the intrusion is unreasonable. That's not the conclusion the court gives us in Terry v. Ohio. It's a different conclusion. And it may be the right one, maybe the wrong one, but that's the issue in Terry, is how are we going to understand whether the police officer's actions comported with the Fourth Amendment or didn't, or violated the Fourth Amendment. And I need to talk about a couple of other things as background before we turn to the facts of Terry. This is the 14th Amendment. And this was passed through the Congress and adopted by the states and imposed by force on some states in 1868 after the Civil War. And Section 1 gives us this clause in the middle that I've highlighted. It's called the Due Process Clause. No, nor shall any state deprive any person. So a state includes its police officers. These are state-level government officials. Nor shall any state deprive any person of life, liberty, or property without due process of law. And a legal question throughout our history since then has been, what does that mean? What does it mean to deprive somebody of their liberty without due process of law? You can be deprived of your liberty with due process of law. You had a fair trial, you had a lawyer, and you were convicted, and you go to jail. You've been deprived of your liberty with due process of law. And one answer to the question of the meaning of the Due Process Clause, what shall it mean with respect to the states, has been to look to the Bill of Rights for the meaning of basic fundamental freedoms that can't be taken away. And if they're taken away in a way that's arbitrary or unwarranted or doesn't comport with the language of the Bill of Rights, then courts will step in and enforce that against the states. Originally, the Bill of Rights applied only to the national government. That was the understanding from before the Civil War, that anything in the first 8 amendments of the Constitution gave you basic rights, but you could only assert them against things done by the national government. They didn't necessarily and didn't, in fact, apply against state governments. Against the state government, you might have a state constitution, you might have state political processes, but you didn't have the national constitution and the federal courts. You couldn't even go there. So does this apply? Does this even apply to a police officer? And it wasn't until 1949 that the US Supreme Court said, yes, through the Due Process Clause, the Fourth Amendment governs the states. And it wasn't until 1961 that the federal courts, the Supreme Court, applied what's known as the exclusionary rule in conjunction with the Fourth Amendment. So let me back up and explain the exclusionary rule. As early as 1914, if you had a federal crime and a trial in a federal court, and you determined that law enforcement violated the Fourth Amendment, which everyone agreed applied to the national government, part of the enforcement of that right was that the evidence obtained through an unlawful, unconstitutional search or seizure would be excluded from the trial, could not be used in a trial against the defendant. This was thought to be a way of enforcing this, of making sure law enforcement obeyed the Fourth Amendment. Whatever it means, if they violated it, the evidence would be excluded. That rule did not apply to the states, that if you violate the Fourth Amendment, the evidence is excluded, until 1961 in a case called Mapp. So the exclusionary rule figures into the reasoning in Terry in a very interesting, and in my view, problematic way, but you need to know what that is in order to read Terry and the argument in Terry about why what the police officer did was lawful, did not violate the Fourth Amendment, and therefore the guns that were discovered in the frisk are not to be excluded from the evidence, and the defendants are convicted properly. All right, so let's talk about Terry, and I'll end after we finish Terry. It's complicated. I want to go through it in a little bit of detail, and I'm asking you to write about it this week, so I want to spend a little time on it. So we're in downtown Cleveland. It's mid-afternoon, and back then in these cities like Cleveland, or where I grew up, Rochester, New York, there would be a kind of a hustling, bustling downtown area. They weren't hollowed out like they are now. Lots of shopping, lots of people working downtown and going out to lunch. And so you can picture that. And we have an officer who's been on the force for over 30 years. His name is Martin McFadden. McFadden is in plain clothes. He's a detective, and it's his beat, or his job, to patrol the downtown area in plain clothes and sort of keep his eye out for anything that might look suspicious or disturbing or problematic. And this is normal police practice. And at the trial, McFadden couldn't say exactly why he started to pay attention to Mr. Terry and his colleague, Mr. Chilton, and a third colleague named Katz. He couldn't say what drew his attention to them in the first place, but once he starts watching them from a distance of about 100 yards, he becomes suspicious. And what he sees is unarguably suspicious. He sees two men on a corner talking, and then one proceeds down the street, stops in front of a store window, looks in the window for a bit, goes on past the store, goes down a ways, turns around, and comes back the same way, stops at the same store, looks in the window again for a bit, and then walks on and rejoins his colleague on the street corner. And then the other person does the same thing. McFadden testifies that he sees these two guys doing this 6 times, at least, each. Okay, so the question I would have for you is, under the Fourth Amendment, like, what should he do? What can he do? It's a little hard to find in the case, but what he observes then, after that, is that they're joined by a third person, and they're leaving this scene. They're walking away from the store when he has to decide what to do. Now, on one hand, there's a strong argument for him to do something, because what he has seen looks like men staking out a store for a robbery, and if it's going to be a daylight robbery, they might be armed. They might be armed and dangerous then and there. It's possible. At the same time, he doesn't have probable cause, right? He doesn't have probable cause that a crime has been committed, and no one in this case really thinks that he does. It looks suspicious, but he can't say he has any evidence of a crime. He wouldn't be able to get a warrant if he went to get one based on these facts to seize or search them, because he doesn't have probable cause. He needs that to get a warrant. And the idea here is sort of as a ground, as what we agree on, is police officers will often see things and they'll have to react quickly that don't allow them to go to a magistrate. Ideally, there's information, there's a reason to intrude upon somebody's privacy and violate their space or their rights. You lay it out factually, and it doesn't have to be evidence needed to convict. It just has to be, a basis for the intrusion, and a judge independently reviews that, signs it, and authorizes it. So you have to go to a third party before you do it. Now, there often isn't time to do that. Often, there's not time to go to a magistrate or a judge and get a warrant. If you don't have time, though, the theory is that if you did have time, you have facts in your knowledge that would give you the warrant, right? You pull someone over for speeding and the marijuana smoke comes billowing out of the car. Okay, that's probable cause to proceed, to conduct a search for the contraband, right? You could get a warrant on those facts, even though there's no time. So we're back here on the street of Cleveland, and McFadden has seen this behavior. It looks suspicious. They're walking away. He has to decide what to do. One answer is he has no basis to intrude or proceed. He has to just live with it. He could follow them and watch them for a while. Do we want him to approach these people and start asking questions? And if he decides to approach them, at what point is the force exerted such that they're detained, right? And in Terry, we get this strange idea of an interaction between a law enforcement officer and a citizen that's not coercive, that's still in the realm of voluntary participation. So I can come up to you, you don't know me, and I'll say, you know, I'm just a regular guy. Can I see your wallet? Can I look in your bag? And you probably would say no, if you weren't threatened, if I did it politely. The idea here, which is strange to me, is that it's the same for a police officer. A police officer can approach and ask questions. And you may not want to answer. You may indicate that you don't want to answer. You may indicate your non-cooperation by walking away. You're not detained until you're detained. When are you detained, and is that detention, if it is a detention, it's a seizure of the body within the meaning of the Fourth Amendment. When does that occur? Well, what did McFadden do? I think out of just intuition and instinct, he followed them. He asked them to show ID. He asked them what they were doing. They gave him a kind of evasive, mumbled response, and he immediately grabbed Terry, spun him around, held his body close to his as a shield, and patted him down. So he's got his arm in an arm lock, and he pats him down, and he finds a weapon. He finds a gun underneath the clothing. So it's definitely a seizure. It's definitely a search. The court is going to call these a stop and a frisk, which a stop is a seizure that isn't quite an arrest. It's short of an arrest. It's a brief detention. And a frisk is a pat down of the outer garments justified by protecting the officer's safety, not to find evidence of crime. That's what the court's going to call these moments. First, there's the level of consent. McFadden could have said, "May I search you?" And Terry could have said, "Oh, yes, please search me." That's a consent search, and the Fourth Amendment is not involved. We haven't gotten to the Fourth Amendment because it's all, in theory, consensual. Does he have any justification under the Fourth Amendment for what he did, which was grab them and frisk them? So it's a stop and a frisk, and he finds the guns. Should the guns be excluded because McFadden violated the Fourth Amendment? That's the issue in the case. What we get in the court's holding and reasoning is that McFadden did not violate the Fourth Amendment. It's an understanding of what's reasonable and unreasonable that isn't tied to probable cause. It's a question of reasonability under all the circumstances. How does the court argue that this is the right result? And there are a couple of prominent civil libertarians, liberals, who render this decision. Earl Warren is known as one, William Brennan. They vote to say that what McFadden did is allowed by the Fourth Amendment. What's the logic of the opinion? This is the assignment for you. What's the logic of this opinion? Can you follow this step by step? And I can summarize it very easily. You get a statement of the facts, as I've just presented them. You get then a statement of the procedural history of the case. The case went through the state courts of Ohio, and the police won and the defendant lost. And then the defendants appeal right from the state courts to the US Supreme Court, asserting that their constitutional rights were indeed violated. The court then canvasses the concerns or values or understandings on both sides. So you get a kind of, the state argues this, defendants argue that, treatment of the problem. And then on page 285 in the excerpt I gave you, there's a key move at the bottom where the court, per Chief Justice Warren, says, but this case also involves the exclusionary rule, that it's not an abstract question, it's a question of whether we admit the evidence or not, right? And then the court goes on to say something that I think is strange and worth thinking about. The court says the exclusionary rule is designed as an enforcement mechanism to incentivize the police to follow the Fourth Amendment. That is, if you violate the Fourth Amendment, you won't be able to use the evidence against the accused. Therefore, you won't violate the Fourth Amendment because you want to convict the person of the crime. You'll follow the rules. In this case, the police officer is reasonably approaching these people to ask questions. He is not primarily interested, given what he's seen, he's not primarily interested in ferreting out crime and investigating crime. He's interested in his safety before he's interested in anything else. He's seen facts. He's seen specific things about these specific persons that would give rise to the inference that it might be a dangerous situation. It might not be, but you can't deny that this is kind of fishy. Do we want him? Is it good police work for him to investigate? That's one important question here. Obviously, the court thinks it is. The court is reasoning, though, that, well, if the motive is the security of the police officer, they're going to engage in this behavior anyway. There's nothing we say about excluding the evidence is going to stop him from protecting himself. And probably nor should it. It's a little fuzzy to me. I don't get this argument about, well, the police are going to do these things anyway, so why exclude the evidence when it won't incentivize following the Fourth Amendment? Isn't the question what it means to follow the Fourth Amendment? Because if the Fourth Amendment means he can't do this because he doesn't have probable cause, then you're never going to find the guns. They're going to walk away with the guns. They may never use them. They may use them tomorrow. He might have saved some shopkeeper from catching a bullet. We just don't know. Lawyers have a saying, hard cases make bad law. And this is a hard case. It's really hard to know how to decide it. The court tries to confine it to its facts. Like, he saw a lot that was personal here. And this isn't a license for you to pursue your hunches and do these things to everybody. But in this case, what he did was reasonable. There needs to be flexibility. The police need to be able to protect themselves. I'll back up to the dissent in a minute and then we'll end. But what you get out of this is this framework that still we live with. Some would say it still tortures us today. Some think Terry is the start of a cascade of evil police practices. And there's a strong case to be made for that it gets its beginning here. Prior to this time, state law enforcement could do pretty much what they wanted, and it was only community control or political control that would stop them, not the federal courts. But you get this framework. You see how law cuts up this very complicated interaction, very context-dependent practice into these verbal moments, right? So there's what's known as a threshold inquiry. And that is the strange idea of a consent search. Should there be any such thing as a consent search in law? Does the idea make sense that a police officer comes up to you, may I search your car? May I look in your bag? And if you say yes, go ahead, I've got nothing to hide, then there's no coercion and the Fourth Amendment is not involved. This happens all the time. We're going to see it be an issue in the Bostic case. I think it's a strange idea because I don't really see the reality of consent when an armed agent of the state is asking. How much crime control and security would we give up if we said in law there's no such thing as a consent search? But the law is that consent searches are perfectly fine. Fourth Amendment isn't involved. The court distinguishes in this case and in the future between reasonable suspicion and probable cause. What the officer needs to make a stop, as opposed to an arrest, what the officer has to have in order to detain somebody, to stop them. Stop is a technical legal term. You're not free to leave. You've been detained for some period of time. Is reasonable suspicion. You need probable cause to arrest, right? So both of these, a stop and an arrest, are seizures within the meaning of the Fourth Amendment. In this case, the court concludes that McFadden had reasonable suspicion. Therefore, he was justified in making the stop. He made it rudely for his own safety, probably, but it was a stop. He didn't arrest them until he felt a weapon. Once he felt a weapon, he had probable cause of an illegal handgun, and he arrested for that. What about this next thing, this frisk? So McFadden does this in sort of one motion. He stops Terry by grabbing him and he frisks him right away. These are separate ideas, separate moments. The court says if the officer reasonably has an apprehension about his safety, has reason to believe that the person he's talking to could be armed, then he's entitled to go further than a detention for questioning. He's entitled to do a pat down of the outer garments. He's not supposed to go in pockets, go in bags. It's a pat down to make sure that the person isn't armed. The purpose is not to find evidence of crime, but the purpose is rather to protect the officer's safety. And that's a search, but it's short of a full and complete search that would happen, say, incident to an arrest. Whenever the police arrest somebody, the law has arrived at the proposition that they can do a full search. So that's the case. Douglas dissents, and Douglas's dissent would be very simple. You read unreasonable in the Fourth Amendment in light of probable cause, right? And if you don't have probable cause, you can't detain. That would be the rule he argues for. He says this opens up a path to totalitarianism. William O. Douglas was quite a character. He was prone to hyperbole, arguably. You should never use hyperbole. Only 1 in a million can do it well. But aside from the flowery rhetoric, the rule he would state is a different rule, and that is no probable cause, no detention, no stopping. You can ask questions, but you can't take away someone's freedom on less than probable cause. Lots of lingering questions. After we have this framework in this case, I want you to think about the exclusionary rule and the motivations of the police officer and whether that logic makes sense. Look, they're going to do it anyway. Why throw out good evidence just because they're not worried about the exclusionary rule? So does it make sense to exclude the evidence? Well, again, to me, the underlying question is, what does the Fourth Amendment mean? And once you decide that, then whether it's excluded or not follows. The court is really arguing that this is reasonable and it should be deemed reasonable, and that's your question. I've asked the consent search question. Reasonable suspicion. Well, hard cases make bad law. What about the next case? Is it any dangerous neighborhood and dangerous situation? Does the officer have to have facts about the individual, as in Terry? Can you use, statistical generalizations and probabilities? But what about all those next cases? What is reasonable suspicion, and how are we going to work that out? The court doesn't want to say. When is the person stopped? Here it's clear, he was grabbed. The next case we'll look at, Mims, it's very clear. Nobody's disputing the stop. It's a traffic stop for an expired license registration. A tag is expired is purportedly the reason for the traffic stop. It's an auto stop, so there's no issue of the stop in Mims. What constitutes a stop on the street? When is the person detained, and how will we know that? When does it end? When is the person free to walk away? So traffic stops, I've often heard, well, you're free to leave. Okay, I know I'm free now. What about the step from stop to frisk? Does it always follow that when you stop somebody, you can frisk them because any situation can be dangerous? Or do we need a separate reasonability inquiry for the stop on one hand and the further intrusion of the frisk on the other? Police officers make a lot of stops without conducting a frisk, but they often conduct a frisk if there's any sense that they could be in danger. Okay, so I'm asking you to give me a summary of the case, give me the logic of the opinion, be mindful of what Douglas says in dissent. It's only a couple paragraphs that we have from the dissent, and give me a brief argument make sure you save a few words, a paragraph to say whether you think this case is rightly decided and why or why not, right? We have competing values here, discretion of police officers and hopefully crime prevention and your security on one hand, and your freedom to be free from intrusion based on hunches or a crime was committed 3 hours ago, 4 blocks away, or whatever it is that's going to be reasonable. Um, which way should this case come out? I'm going to stop there. I'm going on way too long with these. I'm very sorry, but if we were in class, we'd be in class 4 hours a week. So it is what it is, right? So in the next lecture, I will do the next three cases as a group. Mims, the Brown case, where there's a search, but it doesn't yield anything. That's interesting. And the Bostic case, which is a dragnet bus sweep for drugs. Okay, see you soon. Bye.